So, how many workshops are there? There's some choices people have to make, right?
Yeah, there are about 40, I believe, and we've organized them into different tracks. And this is that kind of conference that's a bunch of concurrent sessions. And the main thing that I find over and over again that we hear people say is it's so difficult to choose. So there are only 2 times where you don't get to choose, where you have John Medina speaking in the morning on Friday, bright and early, and then at the close of the conference Saturday, the last program of the day I think starts at noon, and that's Ken Cloak, and so we have those 2 speakers, and then in between you have usually 7 choices of what to choose from.
And we're just looking at the screen right now of amongst the 40 different or so workshops, so there's a lot to choose from. Did you want to? We're doing more with these tracks this year as well.
Well, Jeff is being modest, I think. So yes, we are doing more with tracks this year. But what Jeff did, which I thought was brilliant, is pull together 4 or 5 different topics, and these are all on the website. So when you have access to that and you want to look at these, for those of you who know you're coming, or if you decide to come, you can look at these tracks first if you want to.
How about the tracks page? Can you bring that up? It's in that same menu choice.
So they include brains, community mediation, divorce and family, environment and public policy, ethics, foreclosure mediation, workplace and employment. I think that's it.
Yeah, so based on subject matter areas, who winds up is your interest, there's track suggestions for each one of those. Okay, so you need to make some choices. You got 40, except for 2 sessions, you got to make some choices. And you're going to have to be running around. What's this? I've noticed that there are long breaks, and the lunch is like an hour and a half. How long does it take to eat a box lunch anyway? I mean, why are you taking an hour and a half? What do you do for that?
Okay, because we had this idea several years ago that turned out to be a big hit, so we keep doing it year after year, which is to have a video replay at lunch of 1 or 2 of the speakers from the morning. So in the morning when you're choosing between, you can also be very planful and look to see, well, who's going to be on the video replay? And if I can't really choose between this other great person or great topic, I'll show up at the lunch video replay and watch the live video replay right then. It's the only time that you do get to see it. We don't offer it after that day, after that lunch.
And then some of us can't get out of the hallways to even get into the video replays because we're just chatting up people all the time.
It really is a vibrant community. It's you have the combination of mediators and who are in the legal mediation field, community mediation, and really does draw from the whole Northwest area.
We do have, you mentioned John Medina, we're doing more with plenaries, with everybody seeing the same thing, which creates even more buzz in the hallways because everybody's had the same experience. So we've got John Medina doing our plenary, and some of you who've been to the conference might have seen his presentation. He's been there for, I think, 2 out of the last 4 years, and we got him back for a 3rd. And I think he probably is the person who just kind of exploded from the evaluation forums.
Yes, I'd say John and Nina Meyerding have exploded each time.
Yeah.
Yep.
And we don't get Nina this year, but she's on Bainbridge now, so we get her every once in a while. But we get John Medina again. And am I saying it right? Medina or Medina?
It's Medina.
I know I get it wrong whenever I say it.
That's all right.
Medina. So
I shouldn't say
he
that's
is
all right. It's
a
not
brain
mine.
anatomist, so he's a brain scientist, and we've got, and what we'll show this in a second, we've got a couple of YouTube videos from his, so you can sort of see what his style is, and we'll talk about that in a minute. And then Ken Cloak, of course, he could read, I don't even know what he's talking about. He could read the phone book and I'll go listen to what he's talking about.
Yeah. Ken is doing the language of conflict. Whatever he means by that, I don't know.
And whatever it is, it'll be worthwhile.
Great.
Yeah. Okay, so I think if it would be worthwhile, maybe we can tee up first. Maybe we can find out what the high screaming noise is.
The vacuum or whatever it is.
Yeah, maybe get a door between us closing. But let's get into the 2 different the teasers which you guys have for your programs and what you're going to be talking about. Yeah, so why don't we talk to Sherman?
Sherman Knight.
So Sherman, if I might, tell us what it is that your program's going to be, and who you think would benefit from coming, and what you think they're going to come away with.
So I was at a meeting with Sherman while we're getting this, maybe the noise is going to get calmed down. I was at a meeting with Sherman, and he was telling me about an article that he wrote, and it just sounded great. And he was clearly very animated and excited about this article and the email he had been receiving from people who had read it, with whom it really resonated. So I said, Sherman, you should present that at the conference.
It's been interesting. I've been contacted by different attorneys from 7 different states wanting to publish the article in their state bar magazine. So something here touched a nerve with a lot of people, especially other attorneys. The name of my presentation is I Was Sued and I Didn't Like It. It's a pretty simple concept, but...
Is this like the anti-Katy Perry thing? I don't know.
Could be.
Okay.
Could be. It was, people would ask me at dinner parties, people I didn't know, what do you do for a living? And I would look at them and go, well, I make people's lives miserable. And they would go, you're an attorney. You know, I never really realized what miserable really meant. I'd been practicing law for 2.5 decades, and I've never really gotten into the mind of the people that I represented. I really didn't understand what the word miserable meant. And then it happened. I got sued. We were doing a remodel on our house, and I had hired a friend of mine to come out and take a look at it, make sure the builder was doing the right job. And he calls me up and he goes, man, you got some problems. He gives me the list, and the next day we talk with the builder. Here's what you need to fix, and we're not going to pay any more money until you get it fixed. It's the middle of October, and we don't have a roof on it yet. Needless to say, the builder walked off the site about 2 weeks later. A week after that, I got a lawsuit for a lien foreclosure and what they want, $54,000 or something like that. You know, I looked at it and thought, we're going to cream this guy. I got a pretty good expert. I do this kind of work for a living. I know what's going to happen. So I just kind of wrote it off. Then they served my wife at work. Things changed a lot after that. My wife comes home and she doesn't ask if we're going to win or lose. She comes home and goes, so if we lose, what's it going to cost? I said, well, we got to pay our attorney, and we're going to have to pay their attorney, have to pay them the $54,000, and then we have to spend the money out of our pocket to fix all the mistakes that he made. So, a couple $100,000. Well, she freaked. Our relationship soured as kind of the lawsuit went on for the next 2.5 years. Our relationship didn't get any better throughout that period of time. I didn't get it. As I got closer and closer to trial, all of a sudden I started doubting my own case. Am I really doing the right thing? I've been in the courtroom and I've seen judges come up with rulings that are just, where did that come from? I've had clients that tell me stories, and when I sit down and talk to the other side, their story's completely different. I've never understood how a judge that hears 2 completely different stories I'm doubting my case more and more. It's keeping me up at night. I'm waking up in the middle of the morning with bad dreams. As we get closer and closer to it, I start thinking about, what if the judge doesn't believe me? What if he doesn't like the tie that my expert's wearing? What if? I was shocked at how miserable I was. I never realized it before. What do they teach in law school? What do your mentors tell you? Tell your client to treat it like a business decision. Yeah, right. It doesn't work that way. I was shocked. I realized later that we had everything we needed to do an early mediation on this case. In the end, after 2.5 years, the insurance company wound up writing us a check for a pretty good amount of money. But it didn't take the sting away. It still took 6 or 7 months before my wife quit thinking about it. That part of the misery is something I never understood. So in law school, excuse me, in law school they teach you to be a forensic thinker. Absolutely everything. They teach you to leave no stone unturned. You combine forensic thinking with no stone unturned, and it's ka-ching, ka-ching, ka-ching. It's a lot of money. But that's how law school teaches us to look at the problem. When we first walk out as practicing attorneys, we go to work for another attorney. That's how they teach us to practice law. We listen to the seminars from the insurance companies, and they tell us if you don't turn every stone, if you don't ask every question, you're opening yourself up to a malpractice lawsuit. So when I thought about it in hindsight, there was a problem. So as a mediator, I started working more and more for early mediations. How do we get this thing on track so that we can get this thing into an earlier mediation? Now this is a lot different than what King County tried years ago, where within so many days of filing a lawsuit, thou shalt go to mediation. Frankly, I don't think those work very well. It's more of a structured mediation where the mediator gets involved early on and helps the parties set up limits on discovery, helps explain to the clients that, yeah, you might be giving up certainty in exchange for a lot less misery and keeping a lot more of your own money. It's an interesting discussion that a lot of clients early on, they don't want to hear. But it doesn't take them very long to convince them to do that. We've done a lot of different cases with early mediation. We've done a $20 million case that between the time of filing the lawsuit and settlement was just a couple of days, over 4 months. There are ways to do it, but it requires somebody to come in and structure part of it. If you have two attorneys that have been around the block that respect each other, they disagree with each other, but they respect each other, you know what? They'll find a way to get the information passed back and forth. But if you're dealing with an attorney, especially one that is not met the 10,000-hour rule, yeah, make them a good offer. They don't know if it's a good offer or not. They just don't know. Mediating a case like that is really difficult. So early mediation involves somebody like me getting involved, sitting down with the parties and making sure that they've developed a claim both from liability and, more importantly, from damages, so that we know where the money is. Because in every case out there, I don't care what they teach in law school, the sexy side of law, all about liability. But when it comes right down to it, it's all about the money. And that's it. And there's exactly one class in law school that teaches the money, and that's remedies. And almost nobody takes it.
Okay.
So one of the things you have to do in early mediation is you have to get the parties to figure out how much, what's it worth, and why. And you got to get them to do it quickly, which means they can't turn every stone. If they want to do it forensically, it's not going to happen. The client has to be willing to give up certainty in exchange for getting it done. And then you might have another session with the same parties if there's some discovery issues down the road. But this $20 million case was done with 4 depositions. Everybody had the paperwork. Everybody knew what was going on. That's all that it took. So there are ways to make early mediation happen. It's not just the clock is ticking, we have 3 months. You have to go through a process so that the mediation can be successful. If people just show up, it doesn't have much of a chance. But early mediation, it's a good deal. There are a lot of cases out there that we'll talk about more at the conference that deal with certain types of cases that are just, my God, they're made for early mediation. And we'll go over some of those details and talks about some of those things. Is that what you're looking for?
Well, I was just going to say. So you've taken this experience of personal pain and turned it into something which made a real difference, and for you is a very specific approach in the way that you're approaching a mediation, and that's what the conference presentation is going to cover and explore and flesh out in more detail.
I hope so.
Okay.
It is. I've been excited enough about this concept that I'm trying to push for early mediation that I shut my law practice down. I'm having a lot of fun doing this other stuff. My success rate's really high if I can get the people to work through this process. But the benefit is your client's miserable, but not for very long. Yeah, clients don't get really miserable until the second year of a 3-year process. So if you're done in 4 months, they really haven't had a chance to be miserable.
Okay. Well, thanks, Sherman. What I'd like to do is before we get into serious Q&A on this, we'll hear from, first, why don't we get one of the spots from John Medina. And while that's coming up, I'll just explain that he is a brain anatomist, and he's, there was a conference in which I explained to Kathleen that the 2 programs that were most valuable to me personally were 2 that were presented by people that had nothing to do with the ADR industry. And it was John Medina and her panel of journalists, where she moderated journalists talking about interviewing techniques. And so those were incredibly valuable. So why don't we just hear from this staid, boring scientist person for a couple of minutes? You'll suffer through it. It'll be okay. Just hold on. We'll get to something interesting in a second.
Also be remembered operate in the first few seconds of learning. One of these factors involves something termed a schema, and whether or not the new learning bumps into one. Let me show you an example of a schema by having Dr. Whitehead and myself read a paragraph to you, one actually taken from a famous research paper. Your job is to remember as many facts about the paragraph as you can. Let me tell you in advance that you are going to fail miserably at this task unless I do something first. I can instantly improve your memory score from between 50 to 100% simply by adding 7 little words before you hear Dr. Whitehead and myself. But I'm not going to do that. You will hear the paragraph first, then I will read you the words.
The procedure is actually quite simple. First, you arrange things into different groups. Of course, one pile may be sufficient depending on how much there is to do.
If you have to go somewhere else due to lack of facilities, that is the next step. Otherwise, you are pretty well set. It is important not to overdo things. That is, it is better to do too few things at once than too many.
In the short run, this might not seem important, but complications can easily arise. A mistake can be expensive as well.
After the procedure is completed, one arranges the materials into different groups again. Then they can be put into their appropriate places.
Eventually, they'll be used once more in the whole cycle that have to be repeated. However, that is a part of life.
Did you get all that? No? Let us give you now the 7 magic little words. This paragraph is all about washing clothes. What that sentence provides for you is a mental framework, a way of organizing thoughts around some aspect of the world. We call such frameworks schemas, and you have them about people, situations, objects. This means something profound. Prior knowledge can disturbingly shape how you memorize and retain for long-term storage future knowledge. If a schema is triggered near the moment of learning, that learning is more permanent.
Brain rules.
So that was from Brain Rules, and if you haven't read his book, the website is brainrules.net. The book is Brain Rules. It's a wonderful read, and it talks about how our brains evolved and how they worked, and how they work best. And what Professor Medina will be talking about this year is how conflict affects our ability to make decisions, and what he refers to in his science as the executive functioning of our brains. It basically goes to a very warm place in a handbasket very fast when it's under conflict. So it should be very, very interesting. I am sure that he's going to provide a schema for you to be able to hear and understand everything that he was talking about. I didn't know if either of you wanted to mention anything about Professor Medina before we, I don't know if you had any responses or comments.
One of the things that he said in his workup for this conference topic this time is he said, you might be surprised to learn that the very best thing to do to prepare your brain for mediation or negotiation is to conduct some aerobic activity. Do something aerobic before engaging in the negotiation or mediation. So I'm wondering if he's going to make us, stand up and do jumping jacks.
There will be a jumping jacks involved or
You
something.
think so? Yeah.
So, Kathleen, would you be willing to give us a little overview of what your
Sure.
panel is, and again, who do you think is going to be most interested in coming, and what do you hope they might be taking away from it? What's the schema?
The schema is negotiation, how to negotiate, improving negotiation skills. So this came about through a conversation that Puri Callis and I were having. And Puri's a retired judge, and she's a mediator, and she's with JDR. And we were talking about the idea that attorneys don't necessarily learn in law school. Just like Sherman was saying, unless you take remedies, you don't learn about the damages, the most important part of problem solving for your clients. And Puri and I were talking about the fact that a lot of times attorneys don't learn negotiation through education, through law school. Then what do? You learn it through trial, through the practice of law, right? You just trial and error, and you try different things. And that we see a real difference in the range of skills of attorneys that we work with in mediations. So we said, why don't we start talking about our own observations as mediators? Not as academicians, but just as mediators of what we think are some good skills, what we've observed as being good techniques in negotiation. So that's how that got started. And Puri approached Judge Hillier, who's on the JDR panel. And so the three of us have been meeting periodically and brainstorming examples to use, scenarios that we'll go over. And we try to sort of little game with each other to prepare for this. We said, okay, you have to have deadlines. So we said, let's give ourselves a deadline of about a week. We extended it, so about 2 weeks, because we weren't ready. And we each sat down and made our own list of our top 10 ideas. If you could only say 10 things that are the most important aspects of negotiation, what would those be? So I made a list, Puri made a list, Bruce made a list. We promised to not look at each other's. We circulated them all through email, and then we opened them up and looked at them. And the first thing I found interesting was both Puri and I wrote ours with a sort of positive bent of do this and do that, and Bruce wrote his with the never do this, never do that. So we called it the do's and don'ts. Second thing we noticed is that Puri and I had the same list. It was practically the same. There were a couple variations, but so we integrated and synthesized all of these ideas and are going to present those as part of the talk.
Well, one of the things that I really appreciated starting to mediate is you get to see a lot more different negotiation styles. You have more opportunity to see more people negotiating and more different styles. One, there's more cases. When I was doing complex litigation, I'd be dealing with the same opposing counsel for 3 years.
Right.
But also, in each case, you get twice as many negotiation techniques because you have 2 counsel to watch instead of just 1 opposing counsel.
Such a good
And I'm
point.
always bringing
Yeah.
the same thing myself when I'm representing clients. So I don't know.
So
Did that inform what
dynamic.
you're able to bring into the do's and don'ts? Just seeing so many different styles.
I think that's probably true, yeah. I also would add to what you're saying that the parties that participate in mediation and their different styles and what they need and what's comfortable for them is something else worth observing and noting.
And class actions don't talk, so we never.
Right.
Okay, so we have a couple of different options here, and we have a number of opportunities. What I'd really like to do is be able to turn this into more of a conversation, and I think Helen is prepared. Again, we're not only, I just got the note, we're not only recording this for a webcast, but it is now live streaming. So there's several thousand people watching. Wave, say hi. Probably not. Anyway, but Helen is available, I think, to take that mic and run it around. If you got a comment or a question, either about what either of the 2 presenters have said about their programs or the conference generally, or something else, and she'd be available to run it out to you Phil Donahue style so that you can be recorded for posterity. So at this point, if you have any questions, just interrupt. Just raise your hand. We'll get the mic to you, and we'll get the conversation going in this manner. The other thing we can do until somebody comes up with a question, and before I softball pitch some more to these folks, is we do have a couple more John Medina short videos lined up. So if I hear even a grunt of affirmation that way, we'll just have Helen launch one of those and see what he has to say about something else. So any comments or questions about anything that's happened so far? Anything that's been said? Yeah, Sasha Phillips, yeah.
I have a question, Sherman, for you in terms of early mediation, which I'm also very interested in. But how do you structure the process so that early mediation is effective and the parties feel like they have enough information to go into an early mediation? I know that's a very broad question, but if you could give me sort of a
Actually, it's not.
summary.
There's several parts to it. You know, the first one has to do with the 10,000-hour rule. If you're dealing with two attorneys that have been around the block, they know what they're going to need versus what they want. You're dealing with somebody that hasn't, they have no idea what they need. So what happens in terms of structuring the negotiation is going to be completely
Give us the
different.
10,000-hour rule for those people who might come into this who don't know what that is.
The 10,000-hour rule basically says nobody knows what they're really doing until they've done it for 10,000 hours, basically about 5 years. It's a pretty basic rule that seems to apply to just about everything out there. Even the Beatles.
Beatles, 1969, they took off, okay.
So it's, there's a lot of different parts that deal with it. The thing that I'm running into the most is attorneys telling me that they don't want to appear to be the weak guy. And I give them the same answer, let me talk to them. And it's real simple. I sit down with them and talk about when I had a larger law firm, we did exit interviews after every trial. Not after every client, but after every trial, after every settlement. And there were just the several questions, but the first one was, list all the things that we did that you like. And you know, they're always the 10 same things, you know, except for the bill. But other than that, there were 10 items, but they're all over the map. But we also added one other thing. We also added, what are the 10 things you like the least? And the first answer on every single survey we did, no exceptions, every one was, it took too long. So I can look at some of these people and say, you know, all of us get work by referral. 90% of our work comes from referral. The best referral you can get is when somebody says, my attorney got it done quickly. That's guaranteed new work. So there is a way to talk with younger attorneys. There's a way to talk with everybody about it. I don't have any problems going to somebody and approaching them from, have you thought about this? And sometimes I might not even let them know who's asked me to talk to them first. So there's ways to do it. It can be done. But that first part, the first contact, we've been struggling with it. I've been talking with Judge Nault and a couple of others about how do you create something so that people get involved early. And the court rules are all about process. And the court rules really don't want much to do with having to think a whole lot about it before you get there. It's yes or no, black or white. And the only thing we came up with was that the parties are required within so many months of filing a lawsuit to write the judge a letter telling the judge why early mediation won't work. And that will force them to really sit down and think their way through it. Well, why won't it work? And now you're taking the onus off who's going to be first. But we really couldn't come up with, you know, the usual thing is within X number of days of filing a lawsuit. That kind of stuff really doesn't make them think about it. Doesn't make them wonder, why can't we do this early? But having to write a letter to a judge telling them why it's not going to work, they really have to kind of think their way through it. Don't know if the judges want to read it, but it's really going to make the attorneys think about it. So does that?
So the writing of that is the important thing, not the judge reading it.
Absolutely. You know, My favorite negotiating gimmick is let them think it's their idea. And if they have to write the letter trying to figure out why it won't work, it becomes their idea. They own it. It's a lot easier to work with people like that. Is that what you wanted?
Thank you. Yeah.
Perfect.
Any other questions, comments, snide remarks? Yeah. Fair enough.
Kathleen, would you be willing to share your top 10 list with us?
Oh, sure. I just happen to have it right down here.
You make him come to the conference.
So I'll make it, yeah, Jeff wants me to not share too much.
Hold back.
So I come to the conference.
Leave some bargaining
You've come
room.
to the conference before. Are you coming this time?
I am.
Yeah. So, here's one. I don't know how far we'll go in the top 10 because they would take a while, but here's one. Have settlement goals that address underlying issues and needs and develop a settlement strategy to achieve those goals. Now that might seem pretty straightforward, but I do find that there are times where people haven't thought through that a settlement goal is different than, or can be different than a litigation outcome or trying to predict a litigation outcome. So notice that was paying attention to underlying issues and needs. Doesn't mean that you only do that. You know, you also pay attention to remedies, but paying attention to that and develop a strategy. So, but to develop a strategy, that means as an attorney, you're going to be sitting down with your client and talking this through. I'll pick one more. Understand who the real decision makers are and pay attention to people of influence, not just decision makers. So both things. Understand who the real decision makers are. Who are their people of influence? When we are setting up mediations, you know, we figure out who are all the participants, and we sometimes get surprised, even with lots of effort at intake, to make sure we know who all's come in and have enough rooms for them and all of that. And then you'll see the brother walks in, or the kid walks into, the adult kid. My personal preference is to include as many people as need to be included if they are people who influence that decision maker. The last thing you want is the influencer to be out of the room, you know, out of the process and getting the phone calls, what should I do about this or that, or second guessing it once leaving. We're looking for a durable agreement, so we want to pay attention to those influencers and the decision makers.
And for the rest, you can check the materials, which will be available out here pretty soon. Watch the website for those when those materials are able to be available to be downloaded. And when you come to the conference, you'll get them on a really neat little fun USB drive.
So we have an online question.
Oh, great.
And this speaks to, I believe, Sherman's comments about getting work done quickly. How do you suggest getting work done quickly if you're billing per hour? Doesn't that work against you, or do you suggest a different billing model?
Well, I suppose you got to ask yourself who you're working for. Are you working for yourself, or are you working for the client? And if you're working for the client, there's only one answer. You do the best job you can do for them for the least amount of money. Frankly, if you're an attorney worried about, you know, how do I line my own pocket, you're not going to want to do early mediation. And when it comes time to write that letter to the judge about why it won't work, you won't have any good reasons. But yeah, it does shortcut the process quite a bit. But frankly, I would rather have a lot of clients that I do very little work for than just a couple of clients that I do a lot of work for. My billings are stabilized, my business is stabilized, cash flow is stabilized. There's a lot of reasons for having a lot of small cases rather than just a couple of big ones. So, hope that's what they want.
So the algebra of law firm revenue has more than just hourly rate times number of cases.
Oh, yeah.
Yeah, you're going to get satisfied clients too, as you were saying earlier, who are going to refer more business.
Absolutely.
I will also add that it's worth reading, again, if you haven't read these for a while, the Rules of Professional Conduct, and they specifically use the standard informed client. We have to have, the clients are the decision makers about not just the outcome. A settlement decision is a client decision, not an attorney decision. The mode of representation, the choices that are made in the course litigation, those are client decisions, not attorney decisions. And it's the attorney's job as part of the advice role to spell out, here are your options. And the comments to the RPCs even say, if your matter might involve litigation, you need to talk to your client about mediation.
That's good to hear. Also, I might note another resource, another conference presenter from, I think it was last year, Professor John Landy from, I think he's at Mizzou, and he wrote the book on, his system is called Planned Early Negotiation, but it's an early mediation model as well as an early negotiation model. But the subtitle of the book is How to Solve Cases Early and Make Money Doing It. I mean, that's right there on the front of the book. I mean, he knows what his audience is, and even though he's an academic, he understands that point needs to be made. So pick that book up. It's a good read. Any other comments, questions? Lish, yeah.
You talked about lots of different negotiation techniques, and what I often see is that there's no technique at all. It's all go up from 5 cents to 10 cents, and you'll come down from $3 million to $299.
The Casbah haggle.
And I don't, is that a negotiation technique, or is that just brain dead?
No, that's a technique. It's called the squeeze. And it has, the squeeze has come about, frankly, from a lot of insurance mediations out there. What will happen prior to a mediation in a lot of insurance cases is the parties will sit there and negotiate out the best deal they can. But then for some reason that best deal doesn't work. And then when it gets to mediation, the insurance company is going to assume that the other party's first number at mediation is the lowest number they got in the negotiation before. Well, that party's already gone down to where there's not much more room left. But some insurance carriers work with the cut the baby in half model, and now they're hoping that they got the number down to something that was actually reasonable, and now they hope in mediation they can cut the baby in half. So one of the negotiation principles out there that I don't see very often is when to say no. That's it. We're not going any lower. We know what the case is worth. We know what the possibilities are. We know what our downside is. Our upside's huge. We're not going to go down anymore. There seems to be a fear among a lot of attorneys, well, if we don't do this, they're going to walk away. The number is what the number is, and sometimes your client may just be there. But if you go into mediation with that kind of a mindset, that if we don't settle today, we're done, we're dead, it's over, then you're probably not going to get a very good number. They're just going to chew you up and spit you out. You have to go in with, you have to be prepared. You have to know what's good about your case, what's bad about your case, what it's worth. You have to know where your weak points are. You find out in mediation if they've figured out what your weak points are. There's a lot of things you can do in mediation and negotiate that has nothing to do with the squeeze. But the squeeze is what I typically see. They'll come down 2,000, we'll come up 2,000. You see an awful lot of people wanting to negotiate that way. It doesn't have to be that way. We mediated a case the other day, a malpractice case against an architect. The architect, as defendant, walked away. The insurance company walked away paying nothing. But it was also one of those cases where the way the plaintiff presented their case and put it on, they really weren't entitled to anything either. So you just got to know what it's worth.
And it's making me think of a couple of resources, whether it's a technique or not. It's certainly something we see, and there are techniques to deal with the horse trade bargain, the Casbah haggle, when it gets down to just numbers negotiation. There's some great techniques. Alan L. Haddis' conditional offer approach is a really great way to manage that when they reach impasse on those numbers. Because you got really nothing, if they get into the numbers going back and forth, you really got nothing else to work with but them trading numbers back and forth. And he's got a great technique. Maybe you should do a workshop next year on that, Alan. It's a great technique. Anyway, did you have something on that, what Sherman calls the squeeze?
I could also add that, Lish, I think in addition, what I think you were saying is exchanging numbers and not moving very much, or even irrespective of the amount of movement, a simple exchanging of numbers back and forth, is that a technique? That made me think that to go back to what is the role of the mediator in that kind of a situation. And the mediator's job can be described simply as facilitating a negotiation, helping parties to negotiate. So if as a mediator I'm seeing people starting to exchange numbers that are either not going to be meaningful, might be actually hurting them, or maybe are not sending the message they intend, I treat the numbers as, the number that's being discussed, as an opportunity for conversation. I'll say something like, so what do you think is going to happen if I do go down the hall and give them that number? What are they going to think? And get them to talk a little more about their end game, not to tell me, but to just start identifying it, or throw out ideas like, are you comfortable working with brackets? If it's to the point where we're just talking dollars, is this a point where you might want to consider a bracket, and what would that look like?
And one more resource. I'll make certain that this is in the comments of the webcast, because I don't think I'll get the names right. I think his name is Don Philbin. Have we ever gotten him here for a conference? But he's got a project in a company called Picture It Settled. And what he does is it's a data-driven approach to how that numbers negotiation looks when he actually graphs it out across thousands of negotiations. And so he also knows that it's a very common pattern. We think we're terribly sophisticated negotiators, us lawyers. It's a really common pattern. It tends to be 3 iterations back and forth. That's it. That's usually what it is. And I took a great workshop with him. We just started putting the graphs on the screen. They start going by about every 3 seconds, and then it got faster and faster, and the graphs look alike. So he uses it as an education tool for attorneys with their clients, but also could be used for mediators with attorneys and their clients to be able to sort of say, this is how that negotiation you're into, how it might be looking, because here's how a bunch of other ones look like. So I'll make certain that I get the sites right, and I'll put it in the comments on the webcast.
Terrific.
Any other comments, questions, thoughts? Alan?
I had a thought on the last topic you were talking about.
I kind of thought you might.
The haggling that often occurs. It's something that a group of mediators got together to discuss this. And we discovered that there are actually 2 numbers that everybody's looking for when they come to a mediation. Of course, the goal is to get to a settlement. But on the path of getting to the settlement, the plaintiff's lawyer is looking for not only the minimum amount they will accept, but they're also looking for the maximum amount the other side will pay. And that's a double inquiry, so that that partially explains why they start high. And I did an experiment over a number of years where I was having pre-sessions with parties and asking them to, why don't we start the negotiation? I mean, when you think about how lawsuits are negotiated, you think of the most unscrupulous negotiators you can think of is a used car salesman. The range between a high and a low price on a used car is maybe 20%. I'll sell you that car for $8,000. It might only be worth $6,000. They're not going to ask you for $8,000 for a $2,000 car. Where plaintiff's lawyers will ask for $100,000 on a $30,000 case, and defense lawyers will offer $6,000 on that same case. And I think one of the reasons for that is that they're really looking for both pieces of information. Can the defense lawyer get to that lowest amount, they're the highest amount they're willing to pay, or the lowest amount that the other side's willing to accept, and that might be lower. So that, once I understood that, it made me more at peace with that notion of how people negotiate, and it becomes the mediator's job to just kind of keep the discussion rolling so it can flow to that result.
Interesting. Okay. There is a workshop next year on this. There has to be. Okay, so I'm going to call a little bit of an audible here, Helen, if that's okay, since we got started a little bit late. What I'd like to do is make certain that people have opportunity to avail yourselves of the hosted appetizers, and those of you who are ADR section members, you should have gotten a free drink ticket for the bar. If not, it's a cash bar, and you can help yourself. Jerry will set you up there. What I'd like to do is we'll kind of morph into that. If people want to get going, maybe start, a couple of you, give Jerry some work when she gets back to the bar. and start doing that. But we'll wind up this conversation and turn it into a reception here in just a couple of minutes. If there are any other final comments, questions, sales pitches on getting to the conference, whatever it might be, let's do those. But feel free to somebody start going to the bar right now. Get things going.
May I ask a question?
Sure.
For people here who have not come to the conference, is there something you would like to know? Something you are considering? Or are you thinking of coming? Anything we could tell you?
Or you can put it in the form of friend. Well, my friend who's never been would ask.
Yeah.
You can say it that way.
And I think for attorneys out there, the conference, I've watched it develop over the last, how long has it been?
21 This is the 21st year.
And to me, the thrust of the conference has actually changed quite a bit. And what I see more and more is more and more information that's really good, practical information I can use in my practice. For a while there, I'm not sure what it was, but some of it was kind of out there. Interesting ways of thinking about things rather than, I just want to solve the case and go home. So there's a lot of stuff there. The nice thing about it is you get to pick and choose what you want to watch. And there's a wide variety of topics. So if you can make it, you won't regret it.
So anyone have questions in answer to Kathleen's request for questions about it? No? You're just going to come. You're just going to experience it. It's going to be great. All right. Well, if there's nothing else, we'll put a wrap on this and put a wrap on the webcast. And thank you for coming. Again, register by tomorrow. The early bird registration is off tomorrow. And pick your choices so we can get rooms set correctly. And we'll see you at the conference.
Jeff, thank you for organizing all of this. It was a nice thing for you to do. And I liked this format of, you certainly made it comfortable for Sherman and I.
I'm glad it was comfortable. I had a good time, and if
All right.
I've only amused myself, I've succeeded. But Helen, is the chair of the
Thank you,
membership
Helen.
committee of the
Thank you,
ADR
Helen.
section, is really the one who thank you,
And with that, the bar is open.
Bars.
So I also want to
Hey, the
let
bars.
everyone know there's a laptop set up that's connected straight to the registration page of the conference. So you could register tonight and take advantage of that early bird registration. Also remember there are scholarships available. So that's also open until tomorrow, I believe.
Scholarship deadline is tomorrow, and as of today, we didn't have enough scholarship applications to use all of our funds. So if somebody's thinking about it,
Please
keep
take it
rolling.
tomorrow's the deadline.
And I just wanted to plug, this is the second in our series of 4 events this year. And so please stay tuned for the next few events that are coming up. But every year, this is something that our section does through our membership committee. And so join the section, get this as a benefit. We'd love to have you. You can see a lot of really great people, get to know lots of really great people, build relationships. Also, I'd like to personally thank the moderator and also our 2 panelists today.